Hello, everyone. Thank you so much for joining us for today's webinar. Leach Tishman and Nelson Hardiman are so excited to be launching this new series, Healthcare from the Hot Bench, examining labor and employment issues in the healthcare industry today. Today's program, focusing on non-competes, non-solicitation, and no-poach agreements, is the first webinar in our series, which, over the coming months, is going to be covering the hot topics and emerging issues that employers, and in particular employers in healthcare, need to know about, including independent physicians and a wide range of healthcare organizations. My name is Adela Katz. I'm a healthcare lawyer at Nelson Hardiman who deals with employment issues frequently in the healthcare context. I'm so glad and honored to be moderating a discussion today between two experts in the field, Phil Toomey, a leading employment lawyer at Leach Tishman, and Harry Nelson, the founder of Nelson Hardiman and a leading healthcare attorney. The impetus of today's talk and the series, the significant changes in labor and law in general and in healthcare settings in particular. Phil and Harry both bring their different and unique perspectives today for us. Can I just ask each of you quickly to take a moment to share your background and perspectives as it relates to this issue?
Hi, this is Harry Nelson. Really excited for today's program. I come to this issue as a healthcare lawyer first, but it is almost impossible to advise healthcare providers and healthcare organizations, physician groups, hospitals, and the whole gamut of organizations without employment issues coming up, either as the sort of cornerstone of compliance or in business dealings and coming in contracting. And so we're constantly being asked to deal with questions around employment risk, and today's topic of restrictive covenants. And I'm so excited to be doing this in conjunction with people who are really to do it with a real employment lawyer, because as they say, a little bit of knowledge can be a dangerous thing. So glad to be here today.
Hi, I'm Phil Toomey. I guess I am the real employment lawyer. Thanks, Harry. I've been practicing labor and employment law for over 40 years in both a California-centric and a multi-state environment now. I am also excited to be doing this. I have served many times in the role of being an employer, so I am especially sensitive to the issues that employers, especially in California, face when dealing with the employee work base as well as a collectively bargained work base. So really excited to get into the meat and potatoes of this presentation.
Great. Thank you so much. Before we dive in today, I wanted to, again, thank everyone for joining us today and just throw out a few really important disclaimers. These materials that we're going to go through today are for informational purposes only and are not intended to and certainly do not constitute legal advice or a solicitation for the formation of an attorney-client relationship. Just to be clear, no attorney-client relationship is created through a user's participation in the webinar, nor the receipt of the accompanying materials. This webinar is provided strictly for educational purposes only and is not offered as, should not be relied upon as legal advice. And really, if you're considering what to do with the information you hear today at this webinar, please consult an attorney to address any particular situation. The attorneys at both Nelson Hardiman and Leach Tishman are always ready and available to help. So before we jump into the specific issues today, and before we jump into today's agenda, I really just wanted to frame today's talk and just the series in general. Both labor and employment law and the healthcare landscape are each in such a period of rapid evolution, both at the federal level, as we'll discuss today, and among the states, including our offices here in California. There's a lot to say about these changes that we'll talk about later in this series, but just for today, much of the change we'll talk about relates to employees' rights, and really the balance of power with employers, new protections emerging in response to economic pressures, and to evolving workforce dynamics in the post-pandemic environment. At the same time, healthcare itself is in a period of rapid change, with increased physician mobility bringing into focus concerns about fair and clear agreements that allow healthcare professionals to continue their work without unnecessary restrictions. The pandemic really underscored the need for flexibility in our healthcare workforce, and with increased demand for healthcare providers now, especially in underserved areas, issues like restrictive covenants and non-compete clauses have really been under pressure as an impediment to timely and effective care. That's what makes today's discussion so timely. We're also seeing a huge surge in regulatory scrutiny and legislative activity aimed at addressing fairness and enforceability of these types of agreements. States and the federal government are reevaluating their practices to really strike a balance between protecting business interests and ensuring accessible, high-quality healthcare for all. Of course, there are other issues, including workforce shortages, the rise of telemedicine, and other innovations in healthcare models that bring the issues of restrictive covenants to the forefront. So I want to welcome everyone to today's discussion and to take it as an opportunity to explore these issues in further depth, share unique insights, and really work towards practical solutions. Let's quickly turn our attention to this little agenda that we have before us today. The first topic, and really the first half of this presentation today that we're going to cover, is understanding the unique nature of patients and patient data. We all know that patient information is considered confidential, but is patient data a trade secret? Are patients themselves trade secrets? And what happens to that data when a physician leaves their employments at a healthcare organization? Can they take the patient data with them? Are they prohibited from contacting those patients because the information itself is now considered a trade secret of that healthcare organization? Well, it seems like healthcare organizations like to think that their patients and their data are protected trade secrets, but is that actually what the law provides? We'll discuss that later today. Now, the second half of our presentation will turn to the actual legal issues, enforceability of non-competition, non-solicitation, and no-poach agreements, and really how healthcare employers and organizations can protect their interests. So let's kick this off. Let me ask both of you, are patients really trade secrets?
I think this is a great question. I think there's a lot of misunderstanding in this area. Patients are not customers. And from a labor and an employment perspective, that makes a big difference as it relates to restrictive agreements. And when we talk about restricted covenant agreements, we're talking not only about non-compete agreements, but also non-solicitation or non-disclosure agreements. The California Medical Board has made it pretty clear, and very clear actually in writing, that the patient has the right to choose their doctor, and that there is a duty between not only the departing physician, but the physicians from which someone is departing to communicate clearly with that patient and to assist the patient if the patient wants to transition care. So I think the first key point to understand is that a patient or patients are not customers, and so there is no such thing as like a customer list as it relates to patients in the labor and employment area.
Harry, what's your take on this?
So I think this is a really important kind of foundational point. It comes up in a lot of settings, and there's a lot of confusion. A lot of times we see people negotiate as if patient data, for example, was like an asset of an organization, and we see organizations asserting that departing physicians can't get to this information. But the reality is that when we dive into the actual obligations around records, and I think that's the key concept, is that everything around patient data, both taking care of patients, coordinating care, ensuring appropriate care for patients, and their data, the actual handling of patient data, is an obligation, right? It's a liability. And essentially, the identity of patients and the data of patients are really things that doctors and healthcare organizations are responsible for, not things that they have rights in. So I think once we start with that principle, we start to see how the concept of an ability to protect and limit is really constrained here. And for example, we have up on the slide the California Medical Association, acknowledging that this concept of trade secrets, which I want to get into because I really do think it is that's a debatable concept, but acknowledging that there's this not only a legal right but an ethical right for a physician leaving a practice to contact patients. And if we could just move ahead one slide, I think we can really get to the heart of this issue, right? The bottom line is that providers don't own patient relationships. They owe duties of care. And those duties of care are a duty to actually ensure appropriate care, but also a duty of privacy and data security of the patient's data. They have a responsibility to prioritize the patient's care needs and coordination of care over business considerations. So essentially, what we really see is that providers are custodians of patient data, who, by the way, have obligations to those patients to give access to the patient when they need it, to give access to other providers. And they may have providers, if they have trade secret rights, those are limited to sort of container, the software or the framework in which the patient data is housed, right? But the bottom line is, and I can say this, I've testified as an expert in multiple cases successfully and had my testimony adopted on this point that really providers need to be able to access patient data because they owe duties. And I put up on the right side of the slide some of those duties. What are those responsibilities, right? It's right there in, if you look at the HIPAA privacy rule, it's all framed as responsibilities of providers. If you look in California's state law, for example, the CMIA, you see the same kind of obligation of the provider with respect to taking care of the patient and coordinating care of the patient. We see it, by the way, California has this, and many states have similar Patient Access to Health Records Act, which is a totally distinct obligation of providers to give patients records. And finally, we see this concept in a broader set of laws, including the California Consumer Privacy Act and other laws that are modeled on European GDPR privacy laws, which explicitly recognize that a person has a level of ownership and control over their own data.
Thank you, Harry. And Phil, I just want to bring it back to what employers can actually protect. Can you speak a little bit about what business interests are protectable as trade secrets?
Yeah, I can. I do want to underscore something that Harry just said, because I think from a practical point of view, at least in the litigations that I have handled, there is this mindset that, wait a minute, I hired somebody, they came into the practice group, they didn't have any patients with them, they didn't have access to this information. Everything that they've built, everything they've gained is because of what I invested or what the group invested in the initial time that we put it together. And now you're telling me they get to leave and they get all this information. In essence, they've been able to build their book based upon their experience in our setting. And the answer to that question is probably yes. Sometimes it's a psychological or a perceptive hurdle we need to get over, that all those things that you said may be true, and they probably are true. It doesn't change the legal relationship between the departing physician and the physician group from which he or she is departing. In terms of the protecting business interests, I think Harry summarized it very well. You know, in a traditional sense, if a customer, and I'm going to use that phrase specifically because I think it's important, if a customer would not be easily ascertained from the general population, and the fact that the customer will be looking for a particular good or service, then that is the basic foundation of having a protectable customer interest. Not easily ascertainable, and the fact that they're looking for a good or service is not easily ascertainable, that there would be an investment of capital or effort to find those customers in the first case. So you might think of somebody like somebody looking for life insurance as an example. You can get their name out of a phone book. I remember the days when we did have phone books. You can get their name out of a phone book, but whether anyone on a page of 1,000 names would be looking for a particular type of life insurance, that would require you to call everyone on that page. This is different. And so when we're dealing with patients, I think we're dealing with an entirely different issue. So we go back down to the ideas whether or not initially that is something that's protectable. The other thing that I think is really important, and I do think that it's often missed when you do have a protectable trade secret, is has there been reasonable efforts to maintain the secrecy of the information? Things that I would look for when someone comes to my office would be things like, are there non-disclosure and confidentiality agreements signed? And even more importantly, are those confidentiality and non-disclosure agreements enforced on a regular, uniform, and predictable basis? It's those deviations that always, even when you do have a protectable trade secret, it's those deviations that always come back to haunt you.
Thank you, Phil. Let's turn our attention now to sort of the practical application of this topic. Sort of a broad spectrum question here. Can a departing physician be prevented from contacting their patients and or taking their patient information with them when they leave one employer to another? Harry, maybe you can just breeze through sort of what the law is on this issue in California specifically.
Sure. Yeah. So I'll use California resources, and I will talk about whether there's some variation from state to state, but it's very clear here in California, and I would argue in the vast majority of states, that physicians are protected for advocating for medically appropriate care, and that if the reason a doctor is reaching out to a patient can be grounded in contacting that patient specifically to ensure care, that is going to be protected, right? We in California, we rely on often this is tied to Business and Professions Code Section 2056, which protects physicians from retaliation for advocating for medically appropriate care. And you could say, well, is it really retaliation if you're, but the real question is, what kind of advocacy is going on, right? There's a question always, like, is this doctor marketing, or is this doctor really trying to protect the best interest of the patients and operating from a belief that the doctor's relationship with the patient is essential to the patient's care? And what we see from the courts over and over again is that there's this essential principle of not allowing a physician's judgment on that question to be corrupted. So I could show you cases. I could if I'm the employing medical group, I could say, well, we do great care, but that is not going to undermine that physician who left and is contacting the patient's judgment that they were really seeking the best interest of the patient. This ties back to a case in the 80s, the Wickline case, where there was a criticism that clinical decision making was impaired, and so we have a really strong principle, especially here in California, of protecting physicians. We also, I think it's important to add, have some underlying common law duties in the patient-physician relationship. These are things that are not expressed in the law, in the statutes. They're really out of cases. But what we see is that doctors have a whole series of obligations to patients. Those include the obligation to continue care and not abandon patients with absent good cause, the requirement the duty to act for the patient's benefit and to advocate for the patient, to avoid patient harm, and to keep the patient information confidential. So, basically the bottom line answer is that it's very, very difficult to prevent a physician who has the patient's information from contacting the patient. To go back to Phil's previous point, if the physician, had to download a patient list from software and did so, en masse to something that the medical group took great pains to protect, that would be a different case. But if the provider legitimately had the patient's contact information and reached out to, with this kind of a claim, my belief is that is an absolutely protected activity.
Thank you, Harry. And it seems like the patients may also have the right to sort of select the continuity of care with that same physician when they're moving practices. And this would sort of allow the physician also to communicate with the patient when they're actually making that transition.
That's right. I think it's a good point. I think that in a way, this can be likened to sort of a informed consent process where, our system is generally concerned about giving patients choices, even though healthcare providers and medical groups may not be happy that choice is presented.
Right. Phil, maybe you can comment here. Anything from the Medical Board of California that sort of caught your eye or brings attention to this issue?
Yeah, it's more than caught my eye. This is something that we successfully argued in a case recently when an injunction was sought against a group of departing physicians to prevent them from communicating with the patients that they had actually seen at the older clinical establishment. And the Medical Board of California on their website has a statement, and that statement is that it's responsibility, and I think it's an inclusive statement, so you have to listen to it carefully. It's the responsibility of all physicians and other parties who may be involved in a transaction to ensure that the patient, in the event that the physician is moving practices, that the patients are permitted to move practices and remain under the departing physician's care. Now, that statement is unfortunately included in a drop-down menu on the website involving closing of a medical practice. But it's clear it doesn't refer to the closing of the medical practice because it talks about the transition of a physician from one practice to the next. So the logical argument exists. If there is a duty on the physicians to ensure that in the event of a transition of a physician, the patients are permitted to select the physician of their choice, it's awfully hard to say that the departing physician is not permitted to contact those physicians. I would also like to just underscore something that Harry said. I think there's a world of difference between a departing physician downloading tremendous amounts of data and say they do it before they depart, because I think that there still is the general employment obligation that when you're working for somebody, you owe to that person that you're working for a fiduciary responsibility. So I think that there's a world of difference between doing that and doing this massive download and a situation where a physician would be contacting those patients that physician saw or treated while they were at the clinic.
Great points, Phil. Thank you. Harry, anything from any other agencies or professional associations you've seen here?
You know, the California Medical Association has also commented on this. By the way, I have to say, I don't always agree with the California Medical Association. Their view is that physicians might be able to be prohibited from contacting or soliciting patients if they didn't have an established relationship. And generally, I agree, right? That comes back to that issue of, can you say that you were coordinating care or really interested in the patient when you didn't have a relationship with them? If you didn't have a relationship, it's starting to look like marketing, which obviously, by the way, marketing, both under California law and under HIPAA, requires a specific patient consent. So it's problematic behavior. You know, the bottom line is that it's very clear, the medical records are the patient's, and it's the patient's choice. And so, you know, as long as a physician had a relationship and is really just giving that choice to the patient, they're not going to be able to be stopped from viewing them. I should say, by the way, there's a lot of cases that are ambiguous. The black and white cases, downloading, you know, essentially stealing the list from the software system. But I've had cases where doctors on their way out of a clinic copied face sheets on the Xerox, you know, to make sure they took all the patient information. And it was very interesting in those cases. The doctors might be violating privacy policies, and we can talk more about this later in today's program. But they were actually, the doctors were found in that same case to have been legitimately doing so to coordinate care out of concern that the group they were leaving wasn't in as good a position as the doctors were to provide needed care. So there's a lot of different scenarios in which doctors, patients, and medical records are kind of coming together. And it's very, very important to make sure you're dealing from an established relationship, and to sort of take note of both the responsibilities to the patient and the policies on site. There's a lot of room for both sides of this argument to make their case when you sort of start putting those two issues together.
Thanks, Harry. And sort of expanding beyond California, it seems like the American Medical Association might have some commentary as well.
Yeah, it's very interesting. The AMA, which also I sometimes, you know, hesitate to give them too much authority. They put out a lot of aspirational policies, and it's certainly not stating law as opposed to sort of expectations and standards at an ethical level. But they clearly express that the every physician has a professional responsibility to safeguard confidentiality of patients' personal information. And so physicians therefore have an ethical obligation to manage records appropriately. And so that absolutely ties in here. Classically, like if we think about assuming that you know, third-party payers are being billed, doctors are all covered entities, medical groups are covered entities within the HIPAA meaning of HIPAA, and they all are sharing these obligations, which may work in favor of being able to get access to the records.
Thank you, Harry. Phil, you know, I just wanted to bring this up here. Are there any certain protections for physicians, protections from retaliation for sort of speaking to patients?
I think there's absolute, I mean, we go back a number of years to to have prohibitions in either in agreements or in policies or in practices on a daily basis. I mean, sometimes I hear from somebody, well, we really don't have that written down in a policy somewhere, but I always want to look at what is actually happening on a day-to-day basis. And physicians are clearly protected from retaliation for advocating or communicating to a patient information. And I think that Harry has hit on a really important point, which is I see a blurring sometimes between advocacy for medical care and marketing. There's a blurring there. And it's not always, the cases don't give us the type of clarity that we would hope to be able to see. And so I think it's an area that you have particular care. I will give you an example. In one case, there was an agreement that if the physician left the practice group, which was several offices, that the practice group would communicate with those patients and advise the patients that Dr. So-and-so is no longer with the practice. But the doctor was not going to be permitted to communicate with the patients. That if the patients wanted further information, they needed to call the departing practice. And you can imagine what would occur when that call would come in. There would be all kinds of information conveyed about, oh, gee, yeah, Dr. So-and-so was great. They're no longer with us. We wish him the very best. And we have this new doctor or existing doctors that are going to be able to service you even better. And so then the question is that really communicating to the patient patient information that they need to determine who's going to be their doctor, or is it really just marketing? We're marketing to keep that patient in. And those types of issues are usually developed in depositions of the actual staff people. And when the staff people start giving conflicting instructions, you can imagine what a court might do with that. So certainly if you have a provision in a clause that would prohibit you from communicating directly with the patient, I think it would violate 2056 of the Business and Professions Code.
Thank you, Phil. Very interesting. Let's take some time now to dive into actually non-competition clauses, how employees are or have been historically restricted from communicating with certain persons, competing with the businesses that they were just leaving. So, we've always heard the term non-compete thrown around in the employment context, but what does it really mean for clinicians, and how are non-compete clauses changing in the healthcare context? Harry, maybe you could give us a brief overview of non-competition clauses generally and specifically what we've seen in California.
Yeah, so when I first came to California more than 2 decades ago, I was sort of taken aback by how restrictive California law was in being hostile to non-competes. Back, if you go back a little bit in time, most of the states allowed for employers to restrict competition after an employee left, and courts would enforce non-competes to prevent employees from leaving and setting up a competing shop. California has always had a long history of being hostile to restrictive covenants that limit competition, and frankly, California is what we're seeing now. We could talk more about this. Is really sort of setting a trend that other states are coming to increasingly, that many states have already moved to, and that even some federal agencies we'll talk about are moving to. So, and by the way, California is not just that California had a long-term policy. What we actually see even in the past year is that California is continuing to pass and enact new laws that even further restrict non-competes. By the way, and we'll talk about where non-competes are permitted later in this program. But really interesting to look at these two recent laws that are both in effect as of January 2024. SB 699 basically prohibited employers from attempting to enforce non-competes against California employees, even no matter where they were and when they were signed. If they could have been signed in a different jurisdiction that had a different law allowing more room for non-competes, but it doesn't matter. They're prohibited from being enforced. And if an employer tries to enforce them, the employee has a private right of action to sue for injunction, for damages, for attorney's fees. And by the way, the new part of the other law here, AB 1076, is not only are these laws they're void if they're in employment contracts now, but they're prohibited from being included. And this one really blew me away. As of this year, employers are required to notify California employees if they have a non-compete in an old contract, that they have to give individualized, meaning personalized notice to this employee, hey, that by the way, that non-compete in your old contract is void. So it's not just saying you can't do it, it's now saying you can't even allow for employees to be under a misimpression that they might be bound by these. So this is really kind of setting a maximal position on avoiding on making it impossible to have non-competition in the employment context.
No, I mean, you know, in the face of these extremely stringent restrictions, are there any exceptions that we can see or that are coming
Sure.
up
So
ahead? Yeah.
yeah, so the two exceptions that the one exception that is national is of course trade secrets. Employers can restrict employees from misappropriating trade secrets or confidential information. And even in California, we still see that in the context of a partnership, which would include a limited liability company, where people were partners, working together, and one of them leaves, they could have an agreement to not to compete. And of course, when somebody sells a business, assets and goodwill of a business, that's a third context. So there still are a limited set of contexts in which non-competes can be enforced. Those aren't out sort of, the trade secret one is definitely the one that comes up in the employment context. But these are really quite narrow.
Phil, any thoughts here?
Yeah, I think a couple for first of all, on the whole issue of trade secrets, we get back to the whole idea again of the blurring of the market, the line between marketing and advocacy of care. I have had it raised in cases that I have litigated that patients are trade secrets, and then we just go to the practice group's website and there's testimonials. And so it's awfully hard to argue that you're protecting your patients' trade secret, their identity trade secret, when you also have them doing testimonials. We have done, from a litigation perspective, we have done the Yelp reviews. A lot of practices will ask you to rate them on Yelp or other social media things. So I think that if you're going to treat this as a trade secret, you got to treat it like it's Fort Knox, a trade secret. The other thing on limited liabilities or partnerships or professional corporations, I do think you have to take a real serious look, and I think the courts, at least the trial courts, certainly take a real serious look as to whether or not the ownership interest to which goodwill attaches, which is the reason why you would have an exception under the Business and Professions Code, is a true ownership interest. In other words, is there a sharing of profit and loss? Is there active involvement or a right to active involvement in the management and making decisions? Sometimes I've seen physician practice groups where they give ownership interests, but it's really kind of like a junior ownership interest. We're calling you a partner, but you don't really have partnership authority. And that's still one of those areas that is subject to a large amount of litigation.
Thank you, Phil. Very interesting. For either of you, I suppose, are there any penalties that we can expect for employers in California? We're trying to enforce these non-enforceable non-compete clauses.
Yeah, I'd like to jump on this one because this is one that's been percolating through the litigation world a lot. And it goes back to the Arthur Andersen split up and the Arthur Andersen case. And in that case, when Arthur Andersen went through its split up and its dissolution, they had some of their departing accountants and consultants, this really was more in the consulting area, sign certain types of separation or severance agreements. And within those contained provisions related to privacy, non-disclosure, and non-competes. And there was a litigation that went all the way to the California Supreme Court. And the issue there was, did the inclusion of these provisions, which were clearly not lawful under California law, the strict law that Harry talked about, was the inclusion of those provisions in and of itself a violation of California's unfair business practice law, which is 17-200. The courts have had a mixed result on that. However, going back to the earlier slide that Harry talked about, With the two new provisions that are in California law, I don't think it's even a close issue anymore. I think that if you have those clauses in the contract, or you are not doing the things that those statutes require, you are in violation of 17200. The big issue on 17200, obviously, is that if you're found liable for that, you have an injunction that can be issued against you, but you also have to pay the other side's attorney's fees.
Harry, any thoughts here?
No, Phil's making a great point. This is really becoming a more serious subject. If we can move on to the next slide, I did want to just touch. Phil actually made reference to this whole issue of, are people artificially creating equity interests that aren't real? And I think it's a really important point. There's a very important case here in California called Hill Medical v. Wyckoff, which was exactly that case where a medical group was giving stock, but it was basically, if a doctor left a group, it could take back the stock at the same price. So there was no goodwill. There was no upside that the doctor was really an owner. So those clearly are raise questions about whether the equity interest is real, and that's a case where that basically signaled to medical groups that those kind of arrangements are not going to be a basis for non-competes. The other two places where I would just point out to people where this issue gets more complicated are the question, also sort of implicitly raised in that case, of how much of an interest does the doctor need. And there is no black and white on this, but it, is an infinitesimal, percentage. If you have a very small percentage, is that really enough to hook into? This comes up a lot also in companies that have that are public. We now have a number of medical groups that have gone public, or that have aspirations of like being sort of on a venture path, where many people in the company, including physicians, are getting equity incentives. Are those strong enough? Are they real enough? Is there enough value there to tether a non-compete? And it's a very case by case question, but it's an important one, because many companies are using these kind of equity incentives to be sticky and to recruit and retain physicians.
Thank you, Harry. Phil, any thoughts here?
Just fully on board with Harry. I think the other thing that I see from my practice, since it's not medical practice specific, is that there's a tendency for law to be developed in one area, and then it bleeds over into other areas. And one thing that we have seen in terms of what Harry just talked about is in the area of totally unrelated, and we'll talk about this later in the series, in terms of discrimination. And when just to give a short version, an employee has certain rights that an owner of a business doesn't have. We'll just say with that. So the question can become whether or not this person is an owner, and therefore the business can engage in certain activities that they couldn't do if it was an employee, or whether the person is what we call a PINO, P-I-N-O, partner in name only. And if they are the latter, a partner in name only or an owner in name only, then the courts are looking at it like, wait a minute, this person is really an employee, and the person wouldn't give up the rights to do certain things or to have certain protections for such a small slice of the pie. And that may not be articulated in any appellate court decision, but I've certainly had it said to me by trial court judges.
Thank you. And, we've been discussing non-compete clauses through the employment lens thus far. Phil, does your perspective change about these types of clauses at all when we change the conversation to independent contractors?
It doesn't. And, there's a couple of reasons. One is, in the state of California, I'm not sure, other than the plumber that comes to my house to fix my water heater, what truly is an independent contractor. So I don't. And I do think that when you try to be too creative in this area, inevitably you step on your toes.
Thank you. Expanding our scope beyond California, sort of looking at the national level, do we see the same types of prohibitions for employees and independent contractors from any federal agencies, Phil?
Well, I'd like to tell you that in the years I've done presentations, we used to talk about the majority rule, the minority rule, and the California rule. Like California was out there on its own. I don't use that phrase anymore because I don't think California is out there on its own anymore. I do think that California set a certain standard. Whether it's right or whether it's wrong is not the discussion. They set a certain standard, and you see a morphing towards that standard, even in states such as Texas, that we would say, that's a far different state. We certainly have seen the FTC now make a major move in terms of banning the non-competes. I don't think that for a California-based employer, the FTC rule really should take that much bandwidth or concern. I think we have to deal with the California rules more importantly. I also note that the FTC rule is subject to any number of challenges, including constitutional challenges, whether the FTC even has the authority under any of the enabling legislation to adopt this rule. My gut tells me that the FTC rule will not survive judicial challenge.
Thank you. Yeah, we were just going to turn to this Ryan LLC case. So if you want to just briefly discuss the case and maybe its ruling.
All I can just tell you is that there is a strong political perspective that people should be free to practice their occupation or their employment anywhere, and absent stealing trade secrets and truly proprietary confidential information, anything that restricts that is not going to be enforceable.
Now turn our attention to non-solicitation and no-poach agreements. Are these types of agreements treated the same way as non-competes, or the strict state and federal prohibitions that we've seen just not extended to non-solicitation, no-poach agreements? So let's dive in a bit. Phil, maybe you could provide a brief overview of what non-solicitation agreements are, what kind of issues we see with these types of agreements.
Well, as a general statement, there would be an agreement between two competing businesses that I will not solicit the people that work for you, and that I will not poach or try to hire them, or even in some extreme cases that I've seen, that even if that person found us independently, we will not hire that person. So that's what is generally a no-poach agreement. The question goes beyond whether or not that is contractually enforceable. The question really becomes whether or not this is a violation of the Sherman Act. And if you do have a violation of Sherman Act, it is a criminal violation, or it can be a criminal violation. And the current federal administration has taken the position that in the right cases, the cases that they determine should be looked at, if you have a violation of the Sherman Act based upon a no-poach agreement, they will criminally prosecute that case. And the surgical care affiliates case was the kind of the initial one. And I just think we need to be clear. In the surgical care affiliates case, there were some parties that entered voluntary pleas of guilt to the criminal case. When the case actually went to trial, a jury determined that it didn't violate Section 1. But the Department of Justice came back later and said, irrespective of that verdict, we are continuing on this same path. And there have been subsequent prosecutions. And, again, the burden of finding a criminal violation of the Sherman Act is pretty high. So even though those cases have as well not been successful in terms of being prosecuted, there's a tremendous amount of expense that's involved in there, and there's a tremendous amount of negative publicity. So if someone came to me and said, look, I'm thinking about having an agreement with somebody that, that we're competing for the same group of patients, as an example, and we're going to agree not to hire, say, physical therapists that you have, I would strongly suggest to them that they take a very hard look at the Sherman Act, and also make sure that their insurance policies cover defense counsel's costs when they defend against the criminal case.
Thank you. Harry, do you think then that non-solicitation clauses are at risk of being treated as non-competes? I know you mentioned the Arthur Andersen case a little bit earlier in our session. Maybe you can elaborate a bit?
Sure. Yeah. This Edwards versus Arthur Andersen was a 2008 California Supreme Court case, not a healthcare case, but what was significant about that case was it was a non-compete a restriction in an employee contract that included non-solicitation provisions, and the California Supreme Court just treated them as like one and the same and really didn't differentiate. So pretty much my view for 15 years now has been that in California, you're really at risk of really no distinction being made in the treatment of non-solicitation. And my experience has been that in a lot of healthcare contracts, we would, even though it was, as it became clear that non-competition was not a viable concept, there was a broad use of non-solicitation that has sort of retreated after that case.
Thank you. Very interesting. Harry or Phil, I mean, any final thoughts about no-poach agreements? Are they actually per se illegal? Are they permissible in any context? How does this change, or does it not, in the healthcare context?
My belief is that they are not enforceable, and that my belief is, especially in California, that they probably also violate Section 17200 Business Profession Code. They amount to an unfair business practice. We don't have an appellate court case that clearly says that, but I don't think anybody that in my world, labor and employment specific, would say that that these no-poach agreements do not, in fact, limit the ability of a worker, or in this case, a physician, to freely market her skills.
Harry, any final thoughts on this topic?
I'm with Phil on that.
Great. Let's move forward to sort of the final practical application of this information. How do we protect the interests of your business when we're looking at these types of agreements? So Phil, or excuse me, Harry, what is it that you can actually include in an agreement?
So we've spoken already at length about trade secrets. I absolutely defining what is a trade secret and prohibiting and creating potentially injunctive rights or other rights when a trade secret is misappropriated is a viable option. It's very important, I would say, to define what actually is a trade secret. That term often is sort of abusively overbroad in many contracts, and creating systems to allow you to track activity that might be, putting things on systems that can track who access them is protective, right? The other things I certainly would point to is having non-disclosure agreements, that are likewise reasonable in scope, and emphasize a legitimate privacy interest is something that employers can do. The one thing I alluded to it earlier, and I really can't stress enough what a valuable thing this is for organizations to do, is to put policies and procedures in place that relate to confidentiality of data, data privacy, and security. And so that way, even if when you get into cases where you might be in conflict with a physician or employee's right to access data for one reason, you nonetheless are establishing that employee, in the course of asserting their rights as a physician, violated organizational policies and procedures. Again, those need to be reasonable, but privacy is also a sort of competing priority here, and employers can lean into that. And then finally, just the 2 points here to make that, a lot of this is raising the bar for employers, and instead of using the artificial restriction of a restrictive covenant, is actually just making themselves a desirable place in terms of the compensation and the working conditions to have better retention. And finally, agreements that repay expenses to the employer if the employee leaves the company. So employers can lend money. There's a whole complicated body of law around that for another time, but that certainly is another sort of carrot and stick tool that an employer can use as an alternative to a non-compete.
Thank you, Harry. And Phil, any alternatives to these no-poach or no-solicitation agreements?
Well, I mean, there's certainly things called clean team agreements, and that would be like when a medical practice splits up and things like that you can look at. Again, I think that you have to be very careful about the language. I would go back to something that Harry just said. A lot of times when I see documents, I'm kind of scratching my head as to where the document came from and what was the thought process behind the document. But as equally important, whether or not the employer in this case is taking steps that are consistent with the document. So I think that that's an issue. Clean team agreements, I think you have in the medical practice, I think because of the HIPAA issues, I think you have a leg up on those, but they really don't stop after everybody is split up. They really don't stop the potential solicitation. Non-disclosure agreements, I think, are very important, and something I would just echo that Harry said. The abusive nature of trying to say that everything in the world is a trade secret is so fraught with difficulty. And what a good litigator will do is just go to the employer's website or the customer websites that they're trying to protect and show that everything here that's being described as being a trade secret is generally known. All you got to do is, Google them. So I think you should have some really specific care taken when you draw up what is that protected information that is subject to the non-disclosure agreement. If you want to try to protect a trade secret and you don't have a non-disclosure agreement, that is going to be a very difficult hurdle to clear.
So what do you recommend actually putting into an NDA?
I think you should be very, very specific about what it is that you're going to be trying to protect and think through the process of how you're going to show that this is not just generally available information and is something that really is specific and is protectable. I do think that the damage issue is always a practical issue. In most times when we're involved in litigation of non-disclosure agreements, non-compete agreements, restrictive covenant agreements, the last person you want to put in the middle of your lawsuit are your patients or your customers. That's a good way for you to lose whatever it is that you're trying to litigate over. So I think you should think through that whole issue. Courts are not inclined to give liquidated damages. So I think that a lot of times the litigation should be specific as to injunctive relief, making efforts to stop that. But you need to think through how you're going to prove this case. Are you going to put the 50 patients that supposedly were solicited, are you going to put those patients in the middle of the litigation? Are you going to be subjecting them to depositions? Are you going to be asking them to come to court to testify? I think that those are thoughts that if you think about them and work through those issues at the time you're drafting the document, you have a better chance of success.
And really, at the end of the day, do these alternatives that you're both proposing serve the same purpose and really the same effect as non-compete and non-solicitation agreements?
I think that the courts are going to take a very strong look to see whether or not you're labeling it one thing and you're actually trying to make it perform another.
Right.
And if it looks like a duck and walks like a duck, most likely it's going to be a duck, even though you want to call it an elephant.
Yeah.
And I don't think, and again, it's based upon a political perspective. I don't believe that based upon the current political environment that it's going to reduce any of the antitrust risk.
Okay. Harry, any final thoughts here?
I guess, I really think that these issues, when we're sort of thinking about these issues, the takeaways that I would have from this whole conversation are that, physicians and health professionals are and everyone who's treating patients in healthcare contexts are really facing kind of cross-directional obligations, right? They may have obligations to peer review bodies or to medical groups, to serve them, but they also have these important obligations to patients. They have privacy obligations. They have all the care responsibilities we've talked about that really make this healthcare is a tough environment to enforce non-competition agreements, restrictive covenants in general. And I think what we're really seeing in this time is that California has always been, as Phil alluded, kind of an outlier on this, but not so much anymore, because the directional trend on these issues, both in state law and as we see now with the FTC under federal law, are really also restricting the room for restrictive covenants. And I think the bottom line message and the takeaway that I hope people leave this program with is that if you are a healthcare organization, a healthcare employer, you need to adapt and you need to find new strategies, and not and to realize that the sun is setting on this whole way that these tools that were used by many organizations to try to control their patients, their providers, and those options aren't going to be there anymore.
Thank you, Harry. And Phil, any final thoughts before we sort of jump into some great questions we've received?
Yeah, one thing, and I want to echo something that Harry just said. I mean, I realize there is a tension, and the tension is between healthcare as a business and all of these rules that we have. And that I am not, as a lawyer, I am not insensitive to the issue that we have a business here that we need to run, as well as a highly sensitive, highly professional service to provide to our patients. And there's a tension there. I just see the tension as healthcare, the cost of healthcare becomes much more critical to many people. The ability to attract larger groups of patients is necessary for economies of scales. I think that we're going to continue to see these discussions in this area of the law come forward. So I do think that if I was a healthcare employer, one of the things that I would have is I would ask my professional advisors to help me deal with this tension, and how do I adopt strategies, as Harry just said, that is going to be able to change as times change. The other thing is I can't tell you the number of times I have dealt with employers that had a great policy and then they put it up on a shelf. They adopted it, they put it up on the shelf, and it was a great policy. I agree. It was a great policy in 1986. It just isn't a great policy in 2024.
Right. Thank you so much for both of your final thoughts. Before we jump into some great questions, I just want to highlight, obviously, as you all have heard, this program itself really highlights the extent to which there's significant change afoot in employment law, and especially in the healthcare context, that requires very, very careful attention from employers. In addition to the implications in contracting and in employment, I would really encourage everyone listening to make sure that your organization is updating and is constantly up to date with its compliance programs, policies, and procedures to really take account of these risk issues in the employment and healthcare landscapes. We've received some really wonderful questions during this presentation. So I think we have a few minutes left, Harry and Phil, so let's just jump into a few. Question number 1. After all of the risk issues we've covered, how would you advise organizations that want to use equity incentives to be stickier for their workforce and want to use equity ownership to impose non-competes?
So we talked a little bit about this issue, but I guess I would say if you're going to use equity, it needs to be a substantial enough interest. It certainly needs to be vested. But I think, it really depends on the enterprise, right? I've had deals where buyers of medical groups wanted to know about enforceability and were advised by a lawyer that there was a 5% rule. If the employee has less than 5%, these won't be enforceable. I've had deals where people said, oh, it's a 3% rule. And I think that's the mistaken view. The real question, I think, is what is the value of the equity interest? So if we're talking about a very, very small interest, but in a very, highly valued company where the doctor or the employee has a potentially, multi-million-dollar interest, it's going to be a lot more likely to be enforceable than if we're talking about a very, substantial interest that's only worth a few $1,000s. So I just think it's really tricky here. And my bottom line message would be not to be over reliant on what I would call a skinny equity interest. The more that it really is something substantial and of value, the more likely it is to be something that the courts will uphold, and that opposing counsel representing a provider in that context will be worried about.
Thank you. Phil, any thoughts here?
Yeah, I think that's an outstanding answer. The only thing that I picked up that I'd like to expand on is Harry talked about the value of the interest. I also think you need to see how the interest is valued. And that's, we talked about having written policies and practices, and then what do we actually do in the workplace? I think I agree with Harry. I think there's no magic number. I think the people that have magic numbers are the people that are trying to find a simple answer to a complex situation and doesn't exist. But if you have people that you say are owners in a business, then they should be valued as owners, that their input should be considered, that you should have regular meetings, you should document the meetings, you should have open communication. All of those things, if we ever get involved in litigation, those are the things that we're going to go to. So not only are we saying, look, the value of this, the dollar value of this thing is something that anybody would give up their ability to do certain things, but also this is how we value them. I think that presents a compelling picture to a court.
Thank you both. So thank you so much, Phil and Harry. I think we've run out of time for questions, unfortunately, but as you can see up on the slide here, you can always contact Phil Toomey and Harry Nelson for any additional questions you might have. I want to thank both of you so much for having such a fascinating conversation today on the way that laws around restrictive covenants and employer strategies in healthcare settings are changing and really need to change in light of the advancements and developments we're seeing. Just a little teaser for our next session. We hope everyone will register and join us on our upcoming webinars in this series. Our next presentation will be Thursday, August 1st, where our attorneys will provide insights and practical strategies on the topic of workplace violence prevention and strategies. We have an incredible schedule of hot healthcare and employment topics you won't hear anyplace else, including the issues of harassment and violence in the behavioral health environment, off-campus substance abuse and tech testing in healthcare and behavioral health, wage hour and expanded sick, safe, and reproductive leaves. And honestly, the healthcare from the hot bench list keeps going on. We have so much in store for you, so please keep joining in. You can see the entire series listed if you visit leachtishman.com or nelsonhardeman.com websites, or just search for healthcare employment within the law firm names. We hope everyone enjoyed today's webinar and really look forward to seeing you next time. Thank you so much.